Tonight, a former YMCA counselor accused of impregnating an 11-year-old girl is no longer charged with rape.
So why is the teenage defendant facing reduced charges? News 4's Al Waters first broke this story last month. He brings us the latest tonight. Al?
Well, Don and Jackie, an Erie County grand jury charged the former camp counselor Martell Jones with misdemeanors. Attorneys tell us in most instances a camp counselor having sex with an 11-year-old would be an automatic felony, but this was a rare exception because of Jones's age. The grand jury charged 18-year-old Martell Jones with 2 counts of sexual misconduct. Jones had been facing felony rape charges in city court earlier this week, stemming from an encounter last July with an 11-year-old girl attending summer camp at the Ellicott Maston YMCA.
When this matter originally started, he was charged with B felonies, which carried up to 25 years in prison. So obviously it's a very positive development.
The girl, known in court papers as Jane Doe, accused Jones of getting her pregnant during the rape and gave birth to a baby boy in March.
But these are very serious charges because Martell Jones is facing up to 2 years in jail. He's facing up to 6 years of probation and the possibility of being listed in the sexual offender registration list for the rest of his life.
The girl and her family are now suing the YMCA for gross negligence.
An 11-year-old child has been deprived of her childhood and now is responsible for raising an infant young boy.
By law, an 11-year-old girl is too young to consent to a sexual act known as statutory rape, a felony. So why is Jones only charged with misdemeanors? Attorneys say it's a quirk in the law because Jones was 17 years old at the time of the incident.
If an 18-year-old has sex with an 11-year-old, it's automatically a felony because an 11-year-old is too young to consent. And if a 17-year-old had sex with a 10-year-old, it would automatically be a felony.
Jones was only a few weeks short of 18 at the time, and Jane Doe had just turned 11.
If he had been 2 weeks older, this would have been a felony. If she had been 1 year younger, this would have been an automatic felony.
A few months younger, and she would have been, 10, yes.
Attorneys say other circumstances, such as the use of force, also could have led to a felony. Jones's attorney now says he will ask for youthful offender status when Jones returns to city court on July 14th. Al Waters, News 4 at 5.